Welcome back. Can I ask you, there are two questions here, I think, that have been put to you, or both of them. One is, of course, this question of the public versus the private, because your complaint surely should be amongst the private sector as well as the public. And then secondly, this question of the pool, which is a product of a shocking, egregious education system. The suggestion by Paul Hoffman is that, in a way, there are just not enough black advocates to be competing according to his reading of 217 of the Constitution. I'd like your view on both of those.
I think, first of all, I mean, I can't argue against the minister's indication that the private sector should also be pushed by us to have briefing patterns of a nature that will empower previously disadvantaged individuals, black people and females. That is a fact, and it's not as though this is a battlefield that we are not engaging in. That having been said, it doesn't subtract from the cogency of what we are saying about government taking the responsibility. Because you see, government is supposed to be democratic, it's supposed to be a people's government, and therefore it has got a bigger duty than private sector. I mean, private sector will tell you, no, we are not going to be prescribed to. Of course, government can also take that attitude that they are not going to be prescribed to by us. But I think there's a much more public demand or responsibility on the part of government to put in place a policy that is intended to achieve a particular outcome.
Now, what Hoffman says, Paul Hoffman says, assuming for the purpose of debate that in a particular case, the best person available to lead a legal team would be a white advocate, what do you say then?
You see, I will answer that in two ways. Firstly, we haven't seen an inclination by those expert white advocates of bringing, as their juniors, either black or female.
Some do, don't
juniors. No. There isn't, there's no rush for it.
Okay.
There was an observation that was made by the Chief Justice that in a case in the Constitutional Court where 5 departments of state were represented, all counsel were white males. Even their juniors were white males.
No, I've had that in the Competition Appeal Court, but sometimes that's the attorney's fault too. Attorneys,
I'm saying, what I'm saying is, if it is government,
yeah, they can make an insistence.
Yes, then they can insist and say, no, listen here, Paul Hoffman, if you want to go and fight a case in the Constitutional Court because you think because you are white, you are more skilled than black people, why don't you take Ntsebeza as your junior, skill him in the way in which you are skilled, to such an extent that he is as razor sharp as you are.
All right.
Of course, one of his follies is the fact that he equates whiteness with brilliance. Okay, but then that is Paul Hoffman.
Before I get to you, Minister, I want to put that to Paul. Paul, there are two issues. I mean, there is the, almost as you said it, there's a suggestion that by implication the white advocates are always better. And that's clearly offensive to people.
I can't accept that that's the case. There are terrible white advocates, and there are terrible black advocates, and there are good white advocates, and there are good black advocates. I don't think that that's really the problem. The problem is that anybody who is involved in litigation, whether in the private sector or in the public sector, wants to win their case. And in the public sector, there is an obligation that the public money that is used to procure the services of advocates must be spent in a way that is cost effective. Now,
I'm going to cut you short here. I've got to ask you this.
That
what about that notion that Dumisa is putting to you, that in fact, let's say, assuming that the particular expert that you've got to lead a case as a white person for the purpose of this debate, he then says, why are we not seeing black juniors being brought in? How on earth are we ever going to transform the profession if we keep perpetuating this? That's the point he's making.
Yes, no, I do see black juniors being brought in a lot. I believe that the idea of Chief Justice Chaskelson that was not acted on more than 10 years ago, of creating an internship system for new graduates would be a good way of upskilling the junior ranks of the legal professions, both advocates and attorneys.
Thank you.
That has not been done.
All right, I'm going to ask the Minister. Paul, I have to cut you short. I want to come to the Minister. How do you respond to that? I mean,
well, let me first indicate that there's an elephant in the room here, and that is the fact that
I think there are a couple.
And that is the fact that the Ides of March are come, but not gone. Racism and racial exclusion and all its attributes are still very much part of South African society. It continues to manifest itself in many ways, and the legal profession in particular is not excluded. There is still the exclusion of people from opportunities purely on the ground of their race. People will use their accent not being polished enough, their communication skills, their English not being perfect enough, and all of that.
But isn't that therefore put a bigger onus on you, which is what I think he's saying? That a bigger onus on you. We may not be able to get the private sector to come in as quickly as they should, but sure as goodness government can.
We are accepting the challenge. And hence I indicated, towards the end of this year, we're planning to have a colloquium where we're going to put key themes up for debate, where all the key stakeholders are going to engage. But in the interim, we are going to be putting up a number of policy interventions through Cabinet that would be calculated to give effect to some of this transformation initiatives. One of them, for example, is revamping the Office of the State Attorney. It's been leaderless since time immemorial, and we think it's a very critical conduit to implement government transformation agenda in the profession.
Which would include briefing patterns.
That core to it would be briefing patterns. So what we're looking at there is having this Office of Solicitor General elevated to a fairly senior position that would command the respect within the profession, but also looking at a policy framework that's going to regulate briefing patterns, but also not confining ourselves to state work, but looking into the private sector and looking at how best do we intervene there.
Well, I wanted to ask you about that.
To improve the situation.
I've got to take a break, but I want to come back and we want to debate some of those questions with you.